Good. How are you?
There's one bill if you're watching it here. I swore that they had something up. I thought I saw something up.
Sergeant Lane, it's my fault. It's the Washington Post, actually, so, Delegate Hodges, I think you had a bill first. So just come up, tell us what problem your bill tries to solve and how does it solve it?
Thank you, Mr. Chairman. You have before you House Bill 2484, which deals with identity theft and credit card fraud. Now, crimes involving credit cards and crimes involving identity theft, they often occur together at the same time. But what one of the Commonwealth's attorneys in my district pointed out is there are differences in the venue statutes, which often can create problems when prosecuting these cases. So what we have is identity theft crimes, and they're prosecuted in the locality where the person whose identity was stolen resides, even if the criminal activity occurred in another city, county, or in another town. Credit card crimes, however, they cannot be prosecuted in the locality where the person who owned the credit card resides, where the criminal activity actually occurred in another city or another county. So the result is these crimes frequently must be prosecuted in multiple jurisdictions, and it creates problems for the victims and the witnesses to make court appearances. So what we're looking at to solve this, and you have before you on line 73 and 74, is the language that resolves the credit card crime portion. It just simply adds cardholder resides. And then starting on 53 and 56, what it does here, it allows for credit card fraud offenses to be aggregated in a 6-month period, which is very similar to embezzlement crimes. So this, and I believe this is not mandatory, but it's another tool or another option, and they can be prosecuted in this manner to make it easier for our Commonwealth's attorneys. I'm correct on that.
Okay. Thank you. Any questions for the patron? Delegate Bell.
You seem like both issues are different.
Both issues, but different. But the crimes often occur together at the same time, is what we're finding in the investigation. So it makes it problematic for the Commonwealth's attorneys to prosecute. But may I have some folks that are experts here that may also be able to speak to this as well.
Okay. First, let's hear from other staff attorneys.
Mr. Chairman, the language really in lines 53, I believe, 54, stolen, it's taken from 1922-223, which allows charging of several acts of embezzlement. Basically, it's a legislative caveat to Rule 3A10, which is the joinder of offenses and how they're charged. Typically, when you join offenses and you're charged and tried in the same case, if they're distinct and separate from each other, they're not allowed to be tried in the same case unless a judge finds that that's appropriate under the rule. And this would basically overrule that rule for this certain charge, that the Commonwealth attorneys would basically will have one trial for several distinct acts that are part of a common scheme or plan. So that's the comment on that.
Delegate Bell.
I think I'll just break the staff. I don't know the purpose. I'm a lawyer for Keith.
I've had one bill before the court. This was my second in 8 years. So bear with me.
Must have been long enough that you forgot.
That was supposed to be a simple bill and took 30 minutes, but
So if I just understand staff, the venue only applies to the credit card.
The venue change only applies to the credit card fraud section. It does make it equal to what the ID theft venue currently is.
Where else do we know that as a special venue? That makes more sense than this.
Well, that is actually not tied to embezzlement. There are certain venue statutes, we just changed the forgery one ago to allow for where somebody lost where the loss occurred. That is actually for ID theft as well, and credit card fraud. So there are parts of the code that allow for venue in different areas and where either the defendant or the victim resides. So that's not unusual. It has nothing, the embezzlement does not.
What is, I'm not sure I understand that. It's first in the code, but second, we talked about your venue issue. Where else do we use this provision?
19.2.223, which is charging several acts of embezzlement. Again, the way that every other case works is that under Rule 3A10 and 3A6, charges and offenses can be joined if they are part of the same act or transaction or connected as constituting parts of the common scheme, and they can be tried together. In the embezzlement statute, obviously 19.2.223, which has been around since prior to the Code of 1950, they allow for those acts to be charged if they are distinct acts, not common scheme. And this would take that language and put it in the identity theft. The reason for that rule is because the courts have found that it prejudices when evidence of one crime would not otherwise be admissible in the other trial of that crime, and that is why they have to be separate trials. And so that's the reason for Rule 3A10 and Rule 3A6.
Where else, what other crimes do we have a special aggregation rule for?
There are some crimes that aggregate value over a 6-month period, like credit card fraud is one of them. Bad check is one of them that aggregate value to elevate from misdemeanor to felony. Embezzlement is the only one where we have this language that talks about distinct acts.
All right. Any member of the audience wishing to testify in favor of this bill? That would be the time to come forward.
Mr. Chairman, Mike Second Director of the Virginia Association of Commerce Attorneys. And this bill has been actually very accurately reflected as far as Delegate Hodges' comments. You know, as far as staff's concerned, as far as the rule is concerned, perhaps a fix to that would be to add some language with the identity theft of the same victim. And that way, because right now it could be identity thefts of multiple victims who have nothing in common with one another. But that would be the fix as far as that one is concerned. And then, of course, the venue one, to me, the venue one is just as simple. You've got identity theft, which requires the prosecution to be where the person resides, but that might not be where the credit card theft is occurring. And so you wind up with the same victim going to multiple jurisdictions to prosecute these particular offenses. And this would allow it all in one particular place at one particular time. It's traditionally common measure.
All right, thank you. Anyone from the credit card theft lobbying community wanting to testify in opposition to this bill, please come forward. Okay.
Mr. Chair, I think that what he said is what is giving me a cause of concern here, which is that combining two cases that are unrelated anyway doesn't make sense. We don't do that anyplace else, no matter how helpful it is. I think it does make sense to do that, just like it does if you do 5 times, one employee, one employer, which means you do them all at once. So I don't have that, I don't have the language in my head. I don't know if this new setting has it, so you compare or.
I just dropped the bright idea.
Okay, so, Mr. Chair, I would ask if the chair would consider putting it on for 10 minutes.
Okay, so I temporarily. That's okay. All right, Delegate Rush, the clerk was, he's not here. Delegate Yancey, you were on the Tell us what problem you're trying to solve and how your bill solves it.
Thank you, Mr. Chairman. Mr. Chairman, members, House Bill 2651 is in regards to the creation of a sex trafficking prevention fund. There was, for your reference, there was some time ago a BBC World News radio program in which the commentator they were interviewing about sex trafficking in the United States made a comment that this issue is going on in our communities, in front of everybody's faces, and most people don't even see it. What this bill then seeks to achieve, Mr. Chairman, and was also, I should add, unanimously endorsed by the Crime Commission, is that the Crime Commission found that commercial sex trafficking obviously is a serious problem in Virginia. And so the bill includes the measure to combat commercial sex trafficking by creating a Virginia Prevention of Sex Trafficking Fund administered by the DCJS to promote training, education, and awareness of sex trafficking. Revenues for the fund will be from fees assessed for sex trafficking related convictions, and that would be used for the promotion of awareness on this issue. It would help law enforcement where necessary to be able to better appreciate and how to identify what would be needed there. And then ultimately, this would also help in our communities in an effort to be able to combat this matter by doing just as I began with, letting people know this is going on in their communities, how to identify it, and especially, and most importantly, what to do about it. You happy to answer your question? Go ahead, Mr. Chairman.
All right, thank you. Any questions for the teacher? Staff, what are the offenses for the
On the, for the, just $100 fee?
Start.
Mr. Chairman. It is, my notes would indicate that it's $100 misdemeanor conviction and $500 for each felony conviction.
Okay, I'm just trying to get to rattle off all the offenses.
That's correct. There are quite a few, Mr. Chairman. It's 18.2, just 348 is aiding prostitution or illicit sexual intercourse. 18.2-349 is going to be using vehicle to promote prostitution for the same. Subsection B of 18.2-346 is going to be the prostitution statute. But if that, I believe there's a misdemeanor portion to that, and if it involves minors, it would be a class 5 or class 6 felony. So those are the 18.2-346, 348, and 349. Then we move on to 18.2-48, that's going to be the reduction with the intent to defile such person of any child under 16 years of age, or any person for the purpose of prostitution. Any felony violation of 18.2-344. And that article involves just the commercial section of prostitution offenses in general. So it covers a wide range of misdemeanors and felony offenses, but related to the commercial sex trafficking.
No, Mr. Chair, you might recall this with the crime commission. By far the largest sentencing events were the prostitution. The John statute, the suit that got misdemeanors and a whole bunch of felonies, which are bigger amounts than are huge volume of those as prostitution.
Yeah, I do. Just want to make sure we were capturing both sides of that. The biggest offense. Largest.
It's a solicitation is 346B.
Okay.
Pursue the same with a slightly different side. So no one who has a conviction for prostitution, or a woman who is prostituted, these aren't picked up in this and it's only people mechanism around prostitution.
Right.
I think that's very correct. So 346, 346A are the ones that are kind of not clear or clearly the prostitution. And then the John 346B just captures, supposed to, double check the language, but it captures 346B. Not again.
Okay, anyone in the audience wishing to testify in favor of this bill?
We work with Protect and we support this bill. We're also concerned about making sure that victims of sex trafficking, that these do not end up blind to them. So if there's any way I didn't verify them.
Yeah, and
Anyone in opposition?
yeah.
Okay. There's a motion to second this bill, a second. Any further discussion? Hearing none, please cast your vote.
Right. It will not be.
Close the roll. Bill's recommended to the board. Delegate Hodges, I think, thank you, Delegate. Delegate Hodges, I think you've Bill?
Thank you, Mr. Chairman, and if I may, basically just strike that out, and I believe 18.2, 186.3, and just deal with the venue statute, that would be the bill.
Okay. Delegate Bill apparently moves that amendment. Is there a second?
I move the changes from 53 to 56 be deleted from the.
Okay, well, we need to adopt that change. Does everybody understand those changes? All those in favor say aye.
Aye.
Those opposed, that amendment is adopted, so that will be the form of a substitute. Is there any further discussion? Motion to support substitute. Help me out here, people. Thank you. All those in favor, please cast your vote. It's already gone.
Thank you, Mr. Chairman, members of the bench.
Delegate Stolick, and then you next.
Thank you, Mr. Chairman. House Bill 2665 comes as a recommendation from the Deeds Commission. As you're aware, there are several specialty dockets across the Commonwealth. This would require that the Office of the Executive Secretary of the Supreme Court develop a statewide evaluation model and conduct ongoing evaluations of the effectiveness and efficiency of the local specialty dockets.
Any questions for the patron? Bell.
This is from the Deeds Commission. And we were trying to develop something like this before we actually started doing it. I mean, never been away from what we're doing in this manner. As practically.
Anybody wishing to testify in favor of the bill, please come forward, or otherwise in opposition. No further discussion. Motion. Any further discussion? Hearing none, please cast your vote.
They were working on language.
Thank you, Mr. Chairman.
Thank you. Delegate Lindsay.
Mr. Chairman, members of the committee, this bill is intended to give transparency, we've heard that term earlier today, to the veneer process. The veneer process, for those of us who are non-lawyers, is, well, for those assembled who are non-lawyers, I forget I am a lawyer, is that process where there's a questioning or examination of prospective jurors to make a determination as to whether or not that person comes before the court with some bias or sensibility that would make them not a proper juror. Typically, it happens two ways in the jurisdictions that I've practiced before. It is either a situation where the court has the attorney present questions in advance. Those questions are presented in writing. Or it is a situation where questions are asked by each counsel in these criminal cases, and then the court determines which questions are allowable or permissible and which questions are not. What this bill simply addresses is in two ways. It tries to get to the heart of whether or not people would have sensibilities that would make them unable to serve either in the process of adjudication or the process of sentencing, or whether or not that person has a bias, and that comes out arguably through the examination of the witness. I'm sorry, of the respective lawyers of the prospective jurors. I'll answer any questions of any member of the panel or.
Lindsay, is it your understanding that this provision would overturn cases?
It is not my position, but let me tell you, I don't think that we have continuity across the board. Different jurisdictions do it different ways. Some jurisdictions say, hey, we want you to propose questions in writing. Some jurisdictions say that we're going to ask, we're going to allow you to ask questions that will determine what's appropriate. The only thing that I think that is different is that right now the standard is not to permit jurors to be informed as to the scope of punishment in criminal offenses.
Mr. Chairman, the only language that in this bill that's actually new language is line applicant line 17 through 20, where it says the court and counsel. The rest of the language is actually in 8.1.358, which applies to criminal cases at this point, so that's already there. So it is really just the bill intending to talk about the Hill case from 2002. And in 2002, the Supreme Court of Virginia ruled that neither party has the right, the constitutional or statutory right, to ask jury members about punishment in criminal cases during the trial process. That case has been interpreted since 2002 to mean that it is not a bar against it. It's just judicial discretion to allow questions about that or not questions not about that depending on the case. In 2017, a circuit court judge in Fairfax wrote an opinion basically very well laying out the reasons why a court may allow it or may disallow it, to include jury nullification reasons, mistrial, or an effect on jury sentences, and allowing parties to go into sentencing bias. And so I would submit to the committee that this actually is not a necessary amendment. The state of the law right now is it's the judicial discretion as to whether or not the parties can ask about sentencing. Okay.
If I may briefly respond. Yes, sir. I think the point of my proposed legislation is uniformity. If you are being tried in Southwest versus being tried in Fairfax or being tried in Southampton Roads, it's going to be different rules depending on just the way the court just sees what is appropriate in terms of how to do business. This is an opportunity, I think, to have some consistency and uniformity across the board on this issue of letting the prospective jurors know up front that this is the range of punishment that's associated with this charge. And I'll tell you, that I've had the benefit of being on both sides, being a trial lawyer and a member of the defense bar, being a Commonwealth's attorney, chief deputy Commonwealth's attorney, and there are times that a lot of resource, a lot of time is put into the trial of the case, only to have someone, one person, wind up making it a hung jury. And many times over, it's about whether or not that person who then finds out at the end of their service that this is the sentencing range can arguably make themselves do what the law requires of them. And I think that at least with this up front, you get rid of those persons with sensibilities that would otherwise bring about jury nullifications or hung juries.
This seems like a significant step on your jury, not really a jury that you used to have. Is this, all of us have ideas in the middle of the night that we think sound like they'd be great, and other ones go through the God steps and together, like, is this something that audit can sort of work on with you, or is this one of the, I'm not saying that it's bad, I'm just saying that it's different, big changes from something I think of really.
This is one that was absolutely brought to me. I'm not going to say that in the middle of the night that I had the clarity of thought and creation. But I will say this, as counsel has said, the only departure that we're having, I submit, is in terms of making the process more uniform as it relates to, are we allowing this question, are we not, as opposed to it just being haphazard depending on what jurisdiction the matter is being tried. And I think the benefit is that in so doing this, we have a situation where we don't have the prospect of jury nullification and home jury.
Yeah, but we didn't take a position. That's what I was told.
Anyone in the audience wishing to
John Mahoney, Caroline County. I'm here with the Dean
Supporting, we will be speaking out, just not me.
We oppose this bill, and we think that anything to do with jury nullification leans toward the opposite of what the opponent said. And the only reason to put this in really is an attempted jury nullification across the board. I think it's a very huge problem.
Given that it seems to me when I'm understanding that this is current case law, so codifying it, why would that cause huge problems across the Commonwealth?
Because right now, it would be a judicial exception. In other words, the judge could decide to allow it. I have never seen it done. I've never seen it done. I'm sorry.
I just need clarification. You say you've never seen it done, you've never seen the issue raised, or you've never seen the judge make it?
I've never seen the issue raised in a court.
So what you're saying is that it's rarely used, and the bill then is looking for consistency in the issues.
No, I wouldn't agree. I think the bill is looking for an opportunity to poison the jury by telling them what the range of punishment is.
So you're assuming that consistent is going to encourage decision.
I'm talking about the one part that allows the defense attorney to question the jury about sentences. Do you realize that this offense carries up to 20 years in jail? In the trial? It's a dangerous bill.
Mike, you and I have been this fun. So I used to work for Mr. Doucette 20 years ago.
Who's next on the list?
So we had a case in Lynchburg, I remember it distinctly, where two individuals were charged with assaulting two Lynchburg City police officers in the mall.
Yes.
And there were dozens of witnesses. It happened in the middle of like the holidays or something, and the circuit judge there, who will remain nameless for the purposes of this discussion, allowed the defense counsel, I don't know if he allowed him to argue it, but he allowed the defense counsel to inform the jury in closing argument that there was a 6-month mandatory minimum sentence for the offense of assaulting a police officer. And even though in any other context this would have been an open and shut case, and over the vehement objection of our colleague, Mr. McKenna, I believe at the time, the judge allowed the defense counsel to just tell the jury, hey, just so you know, there's a 6-month mandatory minimum for this. And everybody got acquitted because they didn't want to, so knowing that, and we're just surmising that that's the difference, there was no reason for them to acquit them other than they found out how serious it was. So that's my concern about this concept. If I remember that correctly.
That is correct, yes.
Okay.
And of course, the other issue, of course, is Hill versus Collins seemed to be pretty clear. In the last year, it got fuzzy. So, but until then, it was very clear. But of course, this instance for Fox and what Hill was decided.
Okay, thank you.
Mr. Chairman, if I may have the last word.
Yes, sir.
The only thing that I'd say to you is that much of what I've heard made mention of relates to the sentencing part after a finding of guilt. This is about the venire part. This is about before the case even convenes, make an inquiry about person's sensibilities and whether or not they will follow the law. That's what the veneering process is about. So when I hear things like jury nullification, the jury nullification is more likely to happen on the tail end after the conclusion of the trial, when there's been a situation where perhaps someone thinks that the individual is guilty, but in the knowledge of what the sentencing range might be, they make the determination that, well, maybe this guy isn't guilty after all. But this is a situation where you eliminate, in my opinion, those prospects by upfront gauging people's sensibilities and gauging people's predisposition in one way or another.
Right. Thank you, sir. Delegate Bell.
Mr. Chair, so I appreciate the way Delegate Lindsay has described this approach, but I do think that once the question is asked, to the jury knows this would change the existing understanding, certainly the local understanding, but we are saying that the delegate described it did not see something the jury considers until the function considers. So I will respectfully make the
The motion to be on. Right. You have 2 minutes. If you'd like.
I believe that if you're going to kill me quick.
All right. The motion is to be on. Please cast your votes.
So, motion should be as I can say. So.
Close the vote.
My seatmate voted yes. Thank you, Mr. Chairman.
Thank you, Dylan. All right, then.
Chair.
Yes.
We have a couple of bills for patrons notwithstanding our telling them that they might go to the end of the whole line. We did ask them to have the bills goodbye. I'm saying that because there might be witnesses waiting for them.
Okay, let's announce those.
Mr. Chair, Delegate Pillion on House Bill 2615 has asked that he is special witnesses and he has to.
Let's just let's do the list first.
So it was Pillion 2615, you said Will. House Bill 2448, Delegate Will.
So, is that right?
So, Mr. Chairman, also House Bill 2170.
I have a vague recollection that Delegate J. Jones.
My favorite.
All right. House Bill 2172. 24, 5 today without objection. I can't tell you the name of that. Delegate Boroff, you need to be somewhere. Delegate Friesen, you need to be somewhere.
Thank you, Mr. Chairman, members of the subcommittee. House Bill 2648. And Mr. Chairman, members of the subcommittee, the problem is, right now, under victims' rights, the victim has the right to be notified if their assailant is being released. The exception to that is, however, if the assailant was found mentally incompetent and was therefore not adjudicated guilty, but rather put in a mental facility. This measure would simply put that same mechanism for the victim's rights to then similarly be notified when they are released from the mental facility. This is brought as a specific instance in my district where the individual was found to be incompetent, and when the victim found the assailant at the local grocery store several months later, and then found out he had moved within 3 miles of her residence. If he had been gone to trial and been convicted, she would have been able to know that information, but because he was in a mental facility, she was not. This just simply allows that same right.
Would you look at this as your bill that passed on?
Delegate Bell.
one, with prison, you're kind of out, you're not.
Right.
You're done.
Is the Department of Corrections that notifies you? Does anybody know who notifies you?
Department of Corrections, Sheriff, or Jail Superintendent.
Thinking that a couple of things. First, the Commonwealth doesn't really, once someone goes into the state system as a not guilty by reason of insanity commit, the prosecution done is that they don't keep up with them, they don't know when they are. The sheriff's the same. It's not the criminal justice system anymore, it's the criminal system. I don't know if there'd be a way to have somebody, well, somebody else, just say the Commonwealth will know, they're not coming down.
Although I will say, in this particular case, the Commonwealth's attorney was aware, but felt the law did not allow him to share that information with them.
Okay, so just so everybody knows, we're trying to figure out whose responsibility should it be to tell the victim, which I think everybody would agree, somebody needs to tell them. We just need to make sure it's not the right person.
With my mercy.
Okay, thanks. Anybody in the audience wishes to testify in favor of the bill or in opposition, or really help us fix it, please come forward with one of them.
Mr. Chairman, Michael Say, Executive Director of the Virginia Association of Commonwealth Attorneys. We actually do know about the NGRIs.
Well, that's not.
The NGRI
Part of
is
it, right?
the three, is the two little I.
Okay.
It's the one little I where they've been found incompetent and they go through a civil commitment process that we will never know about. The Department of Behavioral Health will know about it, but we won't ever know about it unless it happens that they just happen to know about it in the Commonwealth Attorney. But we will know about the NGRI because for the NGRI, they're going to have they're going to be committed for a period of time and they may go through I'm trying to remember exactly what the term is. Conditional release, thank you. Or they're outright released, but we have hearings on them periodically. I've done hearings on people who've been NGRI, I've done them for people who've been in the system for 40 years. And we do them periodically, every year and then every 2 years. And then they go through the conditional release and then they go through the final release and we know about it. We can do those, the two are live. We just cannot do the one live.
So actually, that's the opposite of what I would have thought. When they're incompetent, isn't it true that you send them off for competency restoration and they try again and they try again, and at some point they're going to go back to court to say, he's incompetent, he's the case, and we've been notified that he's unrestoring. Didn't become aware of the moment when finally went back to the beginning and says he's not restored.
Mr. Chairman, Delegate Bell, when they're unrestorable, then they're civilly committed. And at some points, and the charges are dismissed, and we're done as far as class attorneys. And they go through a civil process, and maybe 3, 4, 10 years from now, somebody develops a new drug, and they're able to restore their competency, and they're released from that civil commitment. We're not going to do a lot because we're done. The charges are done.
So that's a civil commitment, but it really is right. Some are civil commitment, most perhaps not. You're victims for everyday PDOs. You're not talking about that because that's criminal health. Would you be able to tell them how we can strike that? Or at the point when someone is declared unrestorably incompetent, you could tell the victim. Now they maybe they might be put in the hospital or not, but they can't. We can't proceed. We're telling you we can't proceed. The criminal case is over. I mean,
Mr. Chairman, Delegate Bella, while it's not mandated by law, but I can't imagine a situation where a Commonwealth attorney is not telling a victim of a crime that we cannot go forward because this person has been found unrestorably incompetent. We're going to tell them that. It's what this bill here, though, is saying they've gone through the civil commitment process because they're unrestorable, and then 5 years later they regain a measure of release, and we just will never know about it.
Is there an easy way to behavioral health? Maybe not notify the victim, but it'd be pretty easy.
Behavioral health is here, Mr. Chairman.
Yeah, but I mean, it seems like they could notify you.
That that could be the fix as well, and let us know, but that's not the way the bill is strapped out. And I think we're behavioral health as far as them being able to notify us. And again, of course, this is a situation where the charges are no longer. So, you know, what our standing is or not, and obviously we have standing if you say we have standing.
Well, I mean, regardless of who has to do the work, if there's a victim who needs notifying that the guy who's been obsessing about the bogus these many years is to get out.
And that's why we strongly agree with it to the line. We think that it's important that they know about that, and that we're all for victim notification. It's just a question of do we know about it and to notify the victim.
Isn't, I mean, or maybe it's almost all of them are in GRI, right? It's a fairly, the vast majority of the problems addressed through that, and understandably common, is a tiny number.
That has certainly been my experience, Mr. Chairman.
Looking over your shoulder, but
Yes, I'm Mike Schaefer, the Department of Behavioral Health, and in any given year, we have approximately 80 not guilty by reason of insanity findings common statewide, and probably 20 or 30 unrestorably incompetent stand trial. I was telling Mr. Doucette, every court handles the cases differently. Upon the finding of being unrestorably incompetent stand trial, the court has several options. They can dismiss the charge, they can seek civil commitment under the regular civil commitment, they can seek certification under the training center, or they can seek commitment as a sexually violent predator. The variability comes in some cases that they will civilly convert the person to my custody, but then they will retain the charges. They will not dismiss the charges. This because the code allows you to keep the charges for as long as the person would have served if they had been convicted. If there's charges pending, we do notify the court and the Commonwealth Attorney of our intention to discharge. It's important to remember that criminal court no longer maintains jurisdiction of the person staying in my custody. It's really whoever committed them. It's usually a special justice who has committed them. The problem cases are when the charges have been dismissed without prejudice or has been null pros without prejudice. Then I have no mechanism to tell the criminal court, and then you come into health privacy laws, which again, you recall what you do, but because of health privacy laws, I can't just tell anyone about someone's treatment if there's not a bona fide reason. Again, I can tell them if there's still current charges, because then I have to notify the court because I need to figure out how to resolve the case. So that's where the route comes in.
Would it get us closer if we amended the existing language on line 75 after the word notified pursuant to information received from the Department of Behavioral Health? Where if the department then has a responsibility to notify the sheriff becomes the one who has the information. If the sheriff never gets the information from the department, they have a responsibility. But at least we will help resolve some of these circumstances.
the issue is once, if you go through this process, there really is no connection between, no necessary, it's just, it's a commitment, and I'm not sure that they even know who the prosecutor is, or they don't even know.
And the case, in fact, that brought this up, that they were committed and they were institutionalized for slightly longer than they would have been incarcerated. And so therefore, nothing could be pursued from a legal perspective. They couldn't be prosecuted, they were just turned loose, living 3 miles from the victim.
That I'm not sure.
Do you have
Well,
a way
we
to
can get you most of the way there with the NGRI, but it may be that your case was the other, which would solve it.
So if I solve the one
As chairman of Health HWI, perhaps you can make the rest of the way there by giving an authorization to, on your knees, so that there's not a big issue about sharing.
and I know this committee well enough. If I can get half a bill out of courts, I'm a happy man. So
you get reasonable people to fix it later. Yes, sir.
I was just going to, Mr. Chairman, point out to the committee, there is a victim notification in the not guilty by reason of insanity statutes, and that if the victim requests notification to the commissioner, we do notification under 1921 I believe.
Okay, so wait a minute. The commissioner.
The commissioner.
Okay, the commissioner.
So if the victim writes to us, calls us, texts us, emails us, saying, I want to be notified, we put it in our system and then
Do you intend to notify?
yes.
Okay.
I would tell you, sorry, the problem is people move and people change phones, but we do our due diligence to notify.
Due diligence. Seems to me that the way we solve both of these things, you already have a mechanism for notifying victims of these things upon their request. If we just insert the commissioner where it says attorney for the Commonwealth, you've already got a way to do that, right?
Yes.
I mean, you still may have that, but, right, no, this is upon the victim's request. What? I'm just saying, you make a request for the restoration. You've already got a mechanism by which victims can say, please let us know when Joe Smith gets out. You could just apply that same mechanism to.
You would have to insert it under like 1921 and 69.3. And again, I'm not an attorney, so I don't know if it would violate HIPAA, and so we do it under NJRI, so I don't know if there's special protections for NJRIs versus, because they've been adjudicated.
If the NGRI is taking the system,
But I'm just thinking it would be harder for them to out of the law to make that the system.
oh, no, I like it, no, but you're exactly right. No, that's what you're more or less correct.
Yes, just expanding it to this other group. So.
Yeah, you have somebody in a hospital who's saying this person in the hospital just got out. Again, once you are not competent, that stops it. There's no criminal case of you. Now you're unable to be adjudicated. And it should just like with somebody separately. Mr. I think
Yeah.
I'm gonna step in here real quick. When we did the ECO TDO stuff, one of the things we talked about was notification of family members. And we knew that we couldn't say, Mrs. Smith, Johnny Smith is in the hospital on TDO. What we could say was, Mrs. Smith, we can't tell you a whole lot, but Johnny's in the hospital, you should come down here and find out why. And we found that that was not a HIPAA violation. So I think in the same.
Firstly, you can tell them who's not in.
Correct. Johnny was just released from the hospital, just to let you know, but we can't tell you why he was here.
And I believe HIPAA would come into play if we're telling somebody they've been mentally committed. I don't think there's any HIPAA violations to tell somebody they're out.
Okay. Temporarily, if you need to be somewhere, my home I trust you. Yeah. All right, thank you. Okay. All right, Delegate Creasy.
Thank you, Mr. Chairman. This is HB 2576. This also comes from the Crime Commission, creating a sex trafficking response coordinator position at SJS. As you heard from earlier, a few hours ago, it seems the Delegate Nancy's bill also we have a Crime Commission that the Crime Commission has done a very vigorous study and found that commercial sex trafficking is a serious problem in so they come up with a good recommendation to combat sex trafficking, and that is to create this response coordinator. And there are various localities and agencies in Virginia taking steps to combat sex trafficking. There's just not a centralized point of contact at the state level or any kind of statewide response plan. I'll just read you some. These are some of the regional efforts you can imagine. There's got to be a better way to collaborate statewide. There's the Northern Virginia Human Trafficking Task Force, there's the Virginia Coalition Against Human Trafficking, the Hampton Roads Human Trafficking Task Force, the I-81 Corridor Human Trafficking Working Group, Virginia Trafficking and Central Virginia Working Group, Northern Virginia Human Trafficking Initiative, Virginia Anti-Human Trafficking Coordinating Committee, Human Trafficking Task Force, Virginia Human Trafficking Task Force, Virginia Chief Justice Commission. There's other local ones. So having this bill, what this will allow is to create this statewide coordinated position so that the goal will be a centralized point of contact and development for safety connections between all those various stakeholders law enforcement, prosecutors, witness advocates, treatment providers, social services, schools, courts, in order to combat sex trafficking in Virginia. Sex trafficking intersects with numerous problems. We have child abuse, sex abuse, drug addiction, behavioral issues, school use, delinquency, suicide, mental health, healthcare, gangs, domestic violence. So this coordinated position would really be helpful, and it really allow this one person to really prioritize solely on sex trafficking issues instead, which is becoming quite a problem. And ensures that law enforcement officers receive the necessary awareness training as first responders. This is vital, really, for combating sex trafficking. I think it's a great bill here. It's good, it's important, and it's a good change in this area also.
Anybody in the audience wish to testify in favor of the Crime Commission? Yes, sir. Come on.
Yes, thank you, Mr. Chairman of the committee. Right now, we have a privilege to testify. So here for the Hampton Coalition Against Trafficking. Thank you. Very much appreciate this bill. Very thankful for the work that the Crime Commission did. The staff very diligent in their efforts to not only to survey many different groups, but actually taking particular care of working with survivors. I talked with staff Crime Commission. One suggestion that was the coalition really would like to have seen is that we not limited to sex trafficking, but extended to human trafficking, because there's a number of statutes or sections within the Virginia Code that refer to the federal definition of human trafficking, including severe forms of human trafficking, which would include labor trafficking. So that would be one pickup, but we would not understand the way until sorry. Line 13 bill says sex trafficking. Everywhere there's a line 14 sex. I'm not sure. I refer it down.
Well, we now,
Human 20 would be to substitute the word human trafficking as human for sex.
House Bill 2616 that it talks about the transfer to circuit court. Gary gives this to the Department of Juvenile Justice and then the Court of Bill as well. There is a companion bill at the State Senate that State Senator Dave Marsden is presenting on the Senate side as well. This bill has two primary objectives. One is that it will require the judges, it will provide discretion to the judges before they decide any 14 or 15-year-olds are tried as adults.
Sir, you can just sit. You can have a seat for a second, and then we'll get to you. Go ahead.
In those cases where prosecutors have discretion to certify a case to circuit court, it requires that they take more time and get more information before they make that decision. This bill does not take away the authority of the prosecutor to seek to transfer a youth to adult court. For 14 and 15-year-olds, it requires that prosecutors persuade a judge that circuit court is more appropriate than juvenile court, given the severity of the offense, the youth's criminal history, and other factors. For 16 and 17-year-olds charged with those crimes over which prosecutors traditionally have had discretion to decide, that bill merely provides the prosecutor with important information about the juvenile at the beginning of the process to aid the prosecutor in making an informed decision.
Thank you. Let's staff. Let's break down where the moving parts here again.
Mr. Chairman, this bill changes, so there's three times when a Commonwealth attorney can transfer a child. Right now, the law is either for the age of 14 or older to circuit court for trial as an adult. Subsection A, B, and C. Subsection B is mandatory transfer. If you're charged with murder or aggravated malicious wounding, the juvenile court only has the authority to do a preliminary hearing in the case of mandatory transfer. Subsection C is if the Commonwealth gives notice of their intent to try as an adult, then the court does not have the discretion not to transfer the court to circuit court. That's felony murder, felony assault and battery by mob, abduction, malicious wounding, robbery, carjacking, rape, sodomy, object sexual penetration, possession with intent to distribute, Schedule 1 or 2, third or subsequent offense. And then subsection A is your discretionary transfer, and that's any other felony, and then there's a litany of conditions or things that the court must take into consideration for transferring, such as the age, the maturity, whether the child's been in the system before. What this bill does is it doesn't touch subsection A. So for the cases where there is discretionary transfer, it still allows transfer from 14 years or more. Subsection B and C, which are your mandatory transfer statutes, it changes the age from 14 to 16 years of age. And so it makes it so that if you're 14 or 15 and you commit a murder, that you, the way I read it, cannot be transferred to circuit court.
So big policy shift is what you're saying. Okay, anyone in the audience wishing to testify in favor of the vice versa on this list?
Good afternoon, Mr. Chairman, members of the committee. Andy Block, I'm the Director of the Department of Criminal Justice. And this is an agency bill, just to clarify what staff said. This bill does not prevent 14 and 15-year-olds from being tried as adults. It says that the prosecutors have to seek a judicial transfer, or seek a transfer through a judicial hearing rather than a preliminary hearing. And so it moves the 14 and 15-year-olds to the subsection A category, where both sides present evidence and the court service unit presents a report to the court, and the court is required to consider a range of factors. That's one part of the bill. So it would make it harder to try 14 and 15-year-olds as adults, but it wouldn't take away the authority to do that. The second part of the bill implicates 16.1-269.1 subsection C, which is the part of the bill where prosecutors have discretion. And in discussions with some prosecutors about this part of the process, they have articulated the fact that they don't have a lot of time to make that decision where they exercise discretion because they have to file their notice of intent 7 days before the preliminary hearing. So the bill wouldn't impact their ability to ultimately make that decision. It would just require that they get a report from the court service unit which would detail sort of the life of the young person, the criminal history of the young person, whether they have intellectual disabilities or mental health issues, and aid the prosecutor in making that decision and give them more time. The reason that an agency is seeking this bill is the Sentencing Commission produced data over the summer looking back at the 2016-2017 fiscal year, and only half of the young people who are convicted in circuit court end up with active DOC sentences, and a number of them end up with juvenile sentences or end up getting probation or jail time. And so what this would do would be to give the prosecutors more time and more information prior to making that decision, and maybe winnow out some of those cases that end up getting treated like juvenile cases anyway out just because they have more time and more information. In conversations with Mr. Doucette, the Commonwealth Attorneys Association, and they can obviously speak for themselves, is opposed to the section of the bill that would impact the age, but I think they support the portion of the bill that would give them more time and information before they exercise discretion. And so I think the agency, Delegate Guzman, would be supportive if there were amendments to the bill that would preserve those provisions. Thank you.
Mr. Chairman, I have some questions. I read through the bill earlier. I've been reading through the bill. So if I understand this correctly, if a 14-year-old is charged with, say, grand larceny, okay? The Commonwealth attorney may have no intention whatsoever to charge that juvenile as an adult. The juvenile is being held because it's being held for whatever reason. So now the Commonwealth Attorney has to send a letter to ask for a report to be done, correct?
So grand larceny would not be one of the offenses that would trigger the writing of the letter.
Okay, so what are the offenses that would trigger the letter?
So the offenses that would trigger the letter are, it's under subsection C of 16.11, murder in violation of 18.2-33, felonious injury by mob, abduction, malicious wounding of a law enforcement officer, robbery is the primary one, felonious poisoning. There's a number of offenses. I'm happy to.
So these are the automatic ones, but the Commonwealth Attorney has to actually request that they be sent up to circuit court. Is that correct?
No. So there's two automatics, which are murder and
Okay, I'm sorry.
aggravated
Maybe
malicious wounding.
I misspoke. What I meant was that they are automatic and that the Commonwealth Attorney only has to ask for them to be certified at the circuit court. There's no hearing on that particular issue.
There's only a preliminary hearing to determine whether there's probable cause.
Right.
And so,
And how long, and from the time of arrest to the letter to the preliminary hearing, what is the statutory requirement to have all those hearings?
under the
Current
proposal-
law.
So the proposal does not give a specific timeline.
Now, I'm asking what the current law is now, sir.
No, so the proposal doesn't give a specific timeline. It gives good cause to extend the time limitations that are normally in place, so that such a report can be completed.
Well, I'm doing the math up here, okay? And one of the chief concerns that I have when I practice juvenile law is I have a 14-year-old being held without bond. Can't go home for whatever reason. And we have provisions to protect that juvenile to make sure that they get speedy trial, okay? One way or another, maybe it's preliminary hearing to see if there's enough evidence that to go forward with it. But if my math is right, we're looking at minimum 42 days that they're gonna be held before we have a substantive hearing, because if I look at this right, that once a child is incarcerated, Commonwealth Attorney has to write a letter. It takes 21 days. There's a 21-day return on the report. Then there's an additional 21 days that could happen before there's a preliminary hearing. If I'm misunderstanding that. So that's 42 days that a juvenile who otherwise could have gone through the process is serving that would not count towards anything if they were certified as an adult. Is that correct?
So that's possible, but under current law and current practice, when that young person actually gets certified, even though the certification itself happens more quickly, we have a number of young people who are held a year or 2 years before that initial circuit court decision is even made. So by our estimation, that time in the end, if you're looking at a 2-year time in detention or jail before your case is actually called, is de minimis compared to the ultimate time you might end up spending, not minimizing any extra day that a kid has to spend in detention. That would be. So what we're trying to fix is fundamentally is
Too many
the
kids
unnecessary
incarcerated for heinous crimes.
Not at all.
Okay.
Is that based on the data from circuit court, there are a number of kids who don't seem to need to be in circuit court based on the sentence they receive. They get probation, they get a jail sentence. They're not, if trial as an adult is intended to be for the worst of the worst, only half of them get active DOC sentences. Some of them just get juvenile sentences, some of them even get juvenile probation. So the idea with giving Commonwealth attorneys more time and information before they make their decision is that perhaps they would elect in certain cases, once they have more time to look at the facts and look at the young person, to say, maybe this could be better resolved in juvenile court, in which case it would lead to a more expedient resolution of the case. That's the problem.
Okay.
And so we're wasting resources by having a kid sit for 2 years only to get probation and an adult felony conviction. The case could be resolved more effectively. The case could be resolved more expediently. And I think that would be in everyone's best interest, the interest of public safety, the interest of victims, and the court institution itself.
Okay. Thank you. Anyone in the audience in opposition to this bill, please come forward at this time.
afternoon again, Mr. Chairman. John Mahoney, attorney for Caroline County, here with the Association of Conference Attorneys. Mr. Chairman, you asked a question that I was going to raise. What does this seek to fix? We don't see a problem with it. And the purpose of probation and adult probation is so we can have them under supervision, if necessary, beyond the age of 21. So, we're not seeking to put a 14-year-old in jail for life, in prison for life, but we are looking, because they're at a tender age, and they may not respond to rehabilitation while they're incarcerated, so that we can continue to monitor them as they
Counsel, could you
Mr. Chairman, I think just to clarify what I said earlier, I think the bill could be read in a way that Adrian intends it, but I think it also easily can be read in the way that I read it, which is that it is saying, because of the principles of statutory construction, that when something is more specific in another statute, it controls over the general statute. So by exempting the code sections from B and C from the 14, I don't believe, or I can see an interpretation where it is not placed in section A where it's discretionary. I read that, and I think there's probably many judges that read it the same way. That it means that you cannot certify a kid that's under 16 for those crimes that are listed in B and C.
Okay, thank you. Delegate Collins. Delegate Ransom.
Mr. Chairman, just a mom living in a rural community, this bill frightens me. It frightens me. 6 counties, I tell you, I've been in a courtroom where a cousin, and I'm sorry to be graphic telling the story, but raped a 4-year-old cousin and then beat her to death. I'd like to make a motion to PBI.
Delegate Ransom makes a motion to PBI. Is there a second? Okay, 2 minutes aside. Delegate Collins.
I don't understand the action, but what was just described, those settings, I understand. Touch those mandatories. I don't want to discourage that, please correct me, the bill does not touch that mandatory trial as an adult in the circumstances you described would be mandatory trial as an adult.
To be clear, the bill as proposed would require a judge to decide if they were tried as adults if they were 14 or 15. If they were 16 or 17, it would still be up to the prosecutor depending on how that would charge.
Motion is to pass by indefinitely. Please cast your vote. Okay. Close the roll. PBI, thank you.
Understand that we have language for 2648. Mr. Chair. We have 10 bills before we get to marijuana bill.
You're doing it right now. What do you want us to do? To be clear,
We're just looking at the docket. If you are here, there's a group of marijuana bills, or you're here, if you're glad to be here, we will get to those bills, but it's going to be a little bit.
Oh, so close.
so we should have done it.
Yeah.
All right.
Mr. Chair, I think staff is going to give us the proposed language.
Mr. Chairman, in consultation with the Department of Behavioral Health, the language would be on line 75 of the bill, strike attorney for the Commonwealth, and insert the Commissioner of the Department of Behavioral Health Services or his designee. And then on line 79, strike from or to the end of the bill, place a period after 806. The reason for that is that that provision is already in the NGRI statute. It is exactly upon victim's request that the DHS has to notify them.
Yes, sir. Chair, so this is the victim rights section. You're describing another section. It seems like we'd rather put this there. Creating this complicated mess. Was it in an NGRI section?
That is in, that language is in the section that deals with NGI and we could strike and just say pursuant. It's the statute that charity is in there, so we just strike from or little I2, O2I, pursuant to section 92.
I'm just watching this. Trying to watching it. So basically, we're bill and then
I think we can start with House Bill 2130 and I believe it's
I'm watching.
Do you have classes
But I'm watching these pros and stuff. I think it's going to go down for us.
Thank you, Mr. Chairman, members of the committee. House Bill 2134 seeks to fix a problem that I run into in my legal practice, in which there are several occupational licensing statutes that prohibit folks in Virginia from getting this license because of a previous felony conviction. I will tell you just a quick story about 2134 and why it's good for private security services. I have a client back in my legal practice who was when she was 19. She was sentenced to serve 12 months incarceration and then had 2 years suspended, and that was 10, 11 years ago. She's now my age, she's 30, and all she wants to do is to run her family's private security company, but she can't do that because she, right now, cannot be licensed through the DCJS because she has a felony record. This bill would seek to fix that by saying that if you have a Class 5 or Class 6 felony, and you have served your time and your rights have been restored, or you've been pardoned, that you can in fact get a waiver from the Department of Director of the Department of Human Services to get that occupational license. I think there are several folks out there across Virginia who I know they are who reach out to me and said, you know what, this has happened to me as well. I believe this will get folks back into the workforce. I think to ask them to do what we want them to do, which is to serve their time and get out. They should not be trying to themselves. Summer.
I just wondered, hey, listen to them. We were just mulling over, like, does he actually listen to her?
Different barrier time. What are the actual
I would say that there's a wide variety of classes. There are alarm system monitors, there are mail ombudsmen, there are private security folks who work at warehouses. There's a whole host of things. Administered by the DCJS. I would say that typically most professions in Virginia fall under 54.1-2 or occupational licensing. There are a handful that are broken out by statute. This is one of them. That's why my intention is I actually went to try to apply for a waiver with my client at DCJS. I did this several months ago and really just hit a roadblock. Unfortunately, she had to pay me for my time and I knew what the outcome was going to be.
Clear.
So things like alarm installation?
Yes. It could be residential, it could be commercial. I'll give you the example for my client, our company, does residential and commercial security monitoring services. That is just one of the many private security jobs this person is doing.
So I have a list of 5 and 6 felonies. They include all sorts of things, offense, offense, sex offenses. Could you maybe outline some of the more serious class 5 and 6 that we'd be allowing into the security services?
Well, I will say, Delegate Bell, I don't do criminal law.
No, it wasn't trying. No, I'm sorry. I did correct this.
Oh,
I'm sorry.
I'm sorry.
I'm trying to trick you.
Mr. Chairman, I think some of the more serious ones, possession of firearms by felon, if they're original felony, obviously, 5 or 6, possession of firearm with drugs, possession of any controlled substances, gang participation, unlawful wounding, forgery, DUI third, destruction of property. You already mentioned the third offense, sex offenses, indecent liberties with a minor. It's just a non-exhaustive list of some of the worst, or the not as good 5 or 6 felonies.
Some police officer. What about domestic abuse?
Third offense, domestic abuse. Class 6.
Oh, it's like third offense, beating, third offense, flashing, third offense, sex battery.
I know a guy.
Stalking, third offense, violation of protective order. There are sex offender registry offenses, are there not?
There are.
4226.
This is a policy decision.
So,
Motion
I think our bill is supposed to, our bill should be going by for the day, but if anything happens, it's a USB.
My client actually couldn't be here today, but I'm sure that.
What's your bill number? HB 2454. Okay. What's your last name? Nussbaum, NUS. PA. Thanks.
Look at the underlined section that you're amending. I think the problem with the line of questioning about what's included and what isn't included under felonies is sort of a problem with the underlying wording, because the underlying wording limits the misdemeanors so that it doesn't include anything that might be breaking and entering or anything of concern that someone in a security field limits, and you can't consider them at all if you've done those kind of crimes, and yet when it comes to felony, it says any felony without making those same exceptions so that you're only dealing with felonies that wouldn't be related to the security of the building or occupant or of the household. So with that, I don't know if it can be fixed, but I think the intent is correct, but we need to fix the underlying problem that we're dealing with when it says any felony while being very prescriptive when it comes to misdemeanors.
And Mr. Chairman, I would also add that this, as it's written in the substitute, still gives some discretion to the director of the department, and I do believe that we would like to trust that individual, that they are going to make some informed decisions. Leaving it to the department to do that, I don't think that they would be granting some of these willy-nilly, but I do agree with Delegate Watts in terms of reining in some of this stuff, but I would point out that it still does allow the director to make the waiver.
Do I get it? I don't want to cut off any public comment.
I don't think that it does.
Well, I think this is a moment when there was a time when the restoration of rights was a process whereby individuals were reviewed one by one, and it was seen as a way to indicate whether someone had turned their life around. And when it's going in a direction now, as you all know, that's a very different approach than what we have now. That's no longer a gatekeeper role at all. I don't have any confidence that the same people that are restoring rights without any scrutiny would do any different in this context. All I do know is that we have some barrier cards and they say before we give you these jobs that bring you into individual contact with people in their houses, we have a list of barrier crimes. I think this actually is just a policy decision. You've got something that you want to do, this bill does it, I respectfully disagree. So, Mr. Chairman, I would look to be there.
you guys got,
Sorry.
more pressing stuff to get you behind.
We're hoping they'll leave if we just keep. Okay, the motion is to pass by indefinitely. Please cast your vote. Okay,
Good enough, yeah.
close the roll. Thank you. You have another?
I do have 2135. It is for notaries, and it's the exact same thing, so less people labor the discussion. I'm sure that we will go through the same sort of discourse and spare you guys, because you might have some other things to put in your pipe before the day is over.
Mr. Chairman, this is what Delegado used to say, insert lengthy argument from 3 years ago, argument that I moved to PPI.
There's a motion to PPI. There's a discussion to have here, but I don't know that we can fix it.
I will waive my discussion.
Any further discussion? Please cast your vote. What's that?
Thank you, Mr. Chairman, members of the committee.
Thank you, Doug.
Appreciate your time.
Yes, sir. Thank you.
Enjoy your evening.
Delegate Brewer, I think you were here for next. Which bill? All right.
Mr. Chairman, members of the committee, House Bill 2552 is a cleanup of sorts to filling up the statute, very similar to section on GPS tracking. Right now, law enforcement officers are under drone search warrant are required to notify the individual. Maybe the warrant before the individual.
Yes, that's why I say it. Just really.
And attempting to bring that in line with
read a co-page and
they will let us roll, we will, but they may not let us because hers is already gone.
Okay.
Thanks.
All right, thank you.
Deputy Public Attorneys as well as, the Assistant Criminal Attorney's assistants as well, who might have any additional questions.
All right.
Mr. Chairman, can I ask staff some question? Because this came up in my jurisdiction too. The Commonwealth Attorney was, so as it stands now, absent a search warrant, we can use drones to look at someone's backyard without a search warrant, correct? If I'm in the next neighbor's yard and I send the drone up, I can see in someone else's backyard because that's open space, correct?
I think the statute requires a search warrant.
Okay, that was the question we had, that, we know we can look in someone's window without a search warrant, but to be able, I can fly a helicopter over top of their house and see them growing marijuana, but I can't fly a drone next door up and see them growing marijuana without a search warrant.
That's probably the correct statement.
Okay, and so this bill solves, to a degree, some of those problems, but without having to give notice to the neighbors that we got a search warrant for a drone to go look in their backyard.
I don't, so this code section, the way I've read it, and I've read it many times, I'm happy to be corrected, but I don't see a requirement other than the general requirement that they must be served with a search warrant that requires them to tell them that they're going to execute the search warrant. Search warrant law, or the statutes that cover this state that, it's just general search warrant. Now, the GPS tracking one does have that requirement. It's a separate statute. Under 1954, you just must serve the search warrant after you executed it. And there is a procedure in that statute to seal the search warrant, the affidavit, and the execution, and the return by going to the circuit court on an ex parte basis by the Commonwealth Attorney and asking for the search warrant to be sealed. And so, and again, maybe I'm missing something, but I've read it several times. I don't see where it requires any more than any other search warrant to be served.
So let me see if I can walk through this, because having dealt with the drone stuff last year at length, I don't want to reopen any cans, because hopefully the worms are no longer there. But so if law enforcement says we want you to look in the backyard because we believe that so and so is growing marijuana, they have to go get a search warrant for said drone. In order to use drone to look in the backyard, they didn't have to go to the front door, knock on the door, and say we're here executing a search warrant. So the probable cause for why they need to get, so they wouldn't need to use the drone at all. They can just say, we have a search warrant to search your backyard.
That's correct.
Okay, but now if I get a search warrant for their neighbor's yard, and then you fly the drone, but I see marijuana in the adjoining yard, that's okay, because it's the plain view doctrine, is
I
that?
think you're into an area of law that doesn't have a lot of case law. I'm not sure that that's right.
Okay.
I mean, I think there's an argument to be made that that's plain view, but, you know, this.
I guess what I'm trying to get to is this is something we kind of do need to fix because we have created a mess.
I don't, there may be some procedure that needs to be put into the law that requires, that lays out what the procedure is for service of a search warrant when it deals with drones, like there is one for GPS tracking. But if the issue is we have to tell them before we use the search warrant, there is a procedure in the law to seal that by going to the circuit court. You can have it sealed for, I think it's up to 90 days, and you can go back and have it sealed again.
Okay. Thank you.
Anybody in the audience, council, do you have anything else? Anybody in the audience wishing to testify in favor of the bill, please come forward.
Good afternoon, Mr. Chairman. My name is Derek Colvin. I'm a senior assistant Commonwealth attorney in the city of Suffolk. And I came to Ms. Brewer because of an issue with our police department trying to develop policy. The execution of any search warrant entails a notice component that the current statute just doesn't address. It doesn't address how exactly execution occurs or how notice has to be given. Under a generic search warrant, all search warrants are required to be executed forthwith, and a copy of the documents are required to be served by statute. There are various circumstances where that service does not have to occur contemporaneous with the execution, such as when I secure a search warrant for phone records or for financial records or a trace device. There are specific statutory mechanisms in place to provide notice in a delayed fashion. Now, if I could address the members or the comments in regards to the sealing and what effect that has, that's correct. A seal order can protect the disclosure from the public or even from the target while it is occurring, but it does not affect the service on the target itself. Sealing does not allow the Commonwealth not to provide the target or to serve the target. It protects disclosure to a target prior, and it protects disclosure to third parties, but it does not protect the disclosure to the target himself. That is what the notice provision would fix. It would allow law enforcement officers to use drones not only immediately prior to the execution of the search warrants, but in other surveillance activities and to protect the identity of informants. That's our key concern from our perspective, is being able to use a drone to find an item when we have probable cause, we have a warrant, but also permitting the officers to both comply with the law and also protect other individuals by not having to alert their presence and to potentially alert the target to the basis for the probable cause, meaning the source of knowledge or the informant that provided information.
What's the most common scenario where you use that technology in a criminal investigation?
We haven't used it very much because we don't know exactly how to tell the officers to comply with it.
What would you do?
The particular case that we want to do is there's an individual who's selling drugs to a confidential informant. He's hiding drugs on a location in his property. We're a rural area. There's places outside you can hide things where we don't know where they are. It's not visible from any common place, but we know from the informant that he goes to this location every time, and that's where he stashes his narcotics. In this particular case, you would need to fly a drone over to see where he is hiding his items in order to do it. It would also be used in pre-op surveillance. So instead of having a team of officers running surveillance day after day to try to catch an individual in their home, you could have an officer from a remote location fly a drone up, execute that search warrant, but not have to serve it. And then potentially that has to be done for several days until we can find a target. This would permit delayed notice and it would protect all those issues, I believe.
Thank you.
Thank you.
Delegate Bell, hold on a second.
We call a lot of words. There's a lot of words. Sir?
I'm sorry?
I'm asking a question about the bill.
Yes, sir.
This looks like language which was drafted from, is it word for word from the GPS statute? Or where did this, I mean, there's exceptions and ideas and concepts and all these things. Where did it come? Where did we get this stuff?
To be frank, sir, Mr. Chairman, I did not write this proposed bill. I suggested that it track, or at least track closely to the trap and trace bill. That was my initial suggestion. The wording, frankly, isn't as big of a concern as setting the rules. You know, for law enforcement, it's important to know exactly what the rules are and how you comply with them, so it's not the.
I just don't agree. Having the words right really, I mean, because this is what creates the exception. Do we get this from someplace else, or don't have to reinvent the wheel? Or?
Mr. Chairman, and kind of looking at the language, it seems like it's coming from the Patriot, similar language to the Patriot Act, which is the track and trace.
But is it tracking the state language?
No, the language that is in the GPS tracking statute appears to be somewhat different. For example, I'm looking at it now, within 10 days after the use of the tracking device is ended, a copy of the executed search warrant shall be served on the person. That's the language that's in the GPS tracking statute as opposed to the section.
There's a laundry list of reasons here. Where do they come from?
That seems to come from the Patriot Act. I believe it's section 213. That lays out that.
We really try to use the same language in different sections. The case law tracks ahead. You can just, people get used to one, they can use it in the other. Is there a reason why we're not just taking GPS language?
Mr. Chairman, I am of course not in a position to answer that. From my perspective as an attorney who practices law, I like the language that's in the GPS tracking statute. I didn't mean that the language wasn't important. What I meant was that the criteria or the guideposts were for you to set, not for me. But it's just someone who works with law enforcement, we just want to know the rules.
Right. Okay.
We just like to be consistent.
We find lots and lots of benefits to being consistent with the code. Case law develops, and over time you can use parallel construction to figure things out. And so for us to have multiple, here's the reason why we usually do lists, is just bad statutory construction. We shouldn't do that if we can help it. I'm trying to think of reasons why the GPS ideas would be different than this, and it's the same idea.
So, Mr. Chairman, the issue that I was going to point out to the language is that the language that was taken here doesn't come from any Virginia law. It doesn't say where you go get extensions, where you get the GPS tracking device language gives a very clear direction on how long you have to wait to serve the search warrant, when you can get an extension, and there is good cause that talks about continuing criminal investigation, potential for intimidation, endangerment of the individual, or the preservation of evidence. So if the idea is to make a procedure for which the search warrants are served, subsection E of 19256.2, which is GPS tracking, would fit that bill.
Mr. Chair, I would suggest that we provide 30 minutes and see if staff can do something.
Okay. So we're going to advise temporarily so we can try to accomplish that.
Thank you, Mr. Chairman.
Thank you. Delegate Campbell. Delegate Campbell, you have a bill and it's I believe 2439. Is this your first bill you presented?
No, sir.
All right.
Thank you, Chairman.
Thank you. Just tell us, I guess, the nature of the problem and how your bill.
Okay, this is a technical amendment to the DNA data bank collection requirements. This bill was unanimously endorsed by the Crime Commission as a technical amendment following last year's study on the expansion of misdemeanor crimes in the DNA data bank. This is a cleanup bill to require that DNA samples be taken for any conviction under a local ordinance that is similar to the misdemeanors in the existing list. The bill conforms DNA sample submission statute to the fingerprinting statute. The fingerprinting statute 19.2390 requires that fingerprints be obtained for offenses under 18.2 or 19.2 or for offenses under similar local ordinances. This technical amendment is necessary as a result of work by the Crime Commission. Assault and battery 18.257 and trespassing 18.2119 were added to the list of misdemeanor offenses that require a DNA sample on conviction of the 2018 session. Because of that amendment, the Department of Forensic Science has been receiving some DNA samples from the defendants who have been convicted of local ordinance violations. The bill will provide clarity to law enforcement courts and the Department of Forensic Science on when a DNA sample is required and when that sample can be included in the DNA database.
All right. Thank you, Delegate. Any questions for the patron?
2606 Delegate Ward is identical. The House bill, the one Delegate Price that we did the other day. She would like to roll it in if we can. The problem, Mr. Chair, is that it's already voted on the other one, so I don't know that we're still able to sort of catch up. I told her if we couldn't, we would table it. She was okay with that.
I'm sure they see the problem.
Mr. Chair, I moved that we roll if we can, and if not, we table.
Let's pick one. So,
I mean, yeah, it's gone. It was still before us. I mean,
it's not before us.
I moved to table the bill 2606.
House Bill 2606 was laid on the table until the board talk to the other patron about making sure co-patron already is, so that's solved.
Mr. Chair, I
Wait a
understand.
minute. House Bill 2606, motion is delayed on the table. First block. Strike that. Strike the rule. All right, cast your vote. And again, Delegate Ward, I'm told, is already a co-patron of the bill. Close the roll. All right.
Mr. Chair.
Delegate Bell.
So on House Bill 2592, that McGuire bill that we spoke to you, I think at this point the proper motion is to table it with, as you said, we can always bring things off the table if something magically happens. Well, I don't think to reach the point that otherwise we'll just keep it on our docket for meetings. I would move we table House Bill 2592.
Second. House Bill 2592. Which was a novel approach to emerging crime, but which also upends 400 years of common law.
How many companies? Mr. Chair,
All right, cast your vote. Okay, close the roll. The bill's laid on the table. Delegate Bell.
Mr. Chair, House Bill 2450 for Billicorn, we had notice, and she did say she just did move. I looked at it, I don't know that you can do it in her absence. If you thought it was great, it'd be fine. We just don't know, so.
That's going to go by for the day without objection. House Bill 2454.
So I'm waiting for word from the speaker on Mr. Rush's bill. Delegate Rush understands what the go to motion to these. I'm waiting, I'm literally texting, hoping we get word from him to do that.
So Delegate Hayes has requested to strike House Bill 797.
No, everything was. Mr. Chair, might we, let's strike the table, it's his request.
Let's lay it on the table. So,
Yes.
House Bill 1797, the request of the patron was to strike the bill. However,
They come up with a compromise. It's gonna be the same thing as cheaper.
let's just lay it on the table.
Are you guys opposed to it?
See if, double check with him. You can always take it up off the table. All right, please cast your vote. So it's sort of actually keeping it alive more than he asked us to.
That's right.
Charlie, by the way. Mike, I didn't know where from, because you're not, I just didn't want to put it up.
She's trying to make all right, why don't you go ahead?
One I can grab. 2654
So as we know, this is dealing with the bail bondsmen. Bail bondsmen brought this to try to regulate some of the bad actors within their industry. It deals with surrendering the bond. As what's happening is bail bondsmen are using strong arm tactics to individuals who have not paid all their upfront bonds and threatening to get more money out of them and things of that nature. And this is an attempt. And I have a member of the Bond Association here, the Bondsman Association here to discuss more why they are asking for this bill. But this is going to deal with the bad actors within the Bondsman Association who are exploiting those individuals that are out on bond.
Okay, do you want to go ahead? I think we've gone through the
Chairman, members of the committee, I'm Dave Warren, President of the Prison Bail Association, and we have some situations where some of the bondsmen are actually going to the jails and posting bail for people without being contacted at all. And when the defendant comes out, they've been told that they have about 2 days to pay, then they're going to revoke their bond. And essentially, it's actually borderline extortion. We tried to talk to the police about it. They say that it's a civil matter, and we talked to the Department of Criminal Justice investigator who says that they're regulated. So what we're trying to do is make it less. The bail agent has to surrender the 10% at the time he applies for revocation. Then there won't be a need for him to get people out of jail for free because I don't think we'll take that chance.
All right, so we break it down again. What is the practice, the nefarious practice that's going on?
The bail agent will go to the jail with a list of names that he's either gotten off the internet or somehow found that the person is in jail with bond. Nobody has contacted his bail bond. He posts the bond, the defendant comes out, and then he tells him, you have 2 days to pay me.
Permanent revocation.
Or I'm going to revoke your bond. We've heard of instances where they've actually went to the family, to the parents, and forced them to pay under duress. Put their son back in jail. So it's really a sticky situation. But if that was my business practice, and I had to go down and put up the 10% to get the revocation, then I would make sure I collected that 10% before I got the person out.
So if it's a legitimate revocation, again, how do you get your money back? I mean, they don't have to put up, they don't have to lose that money.
But yeah, the way that reads is for any reason other than a show cause issued by the court. So if the person has failed to appear, there wouldn't be a need to surrender the 10%.
Okay.
But in the event that
Let's just say you hear they're using drugs again, and you're like, I'm not dealing with this, and you go pick them up. Is that what you're talking about?
Right, they would have to surrender the 10%, they can pick up, and then they can petition the court to show cause why they would be entitled. If there's a legitimate revocation, and the judge says, yes, there's a legitimate revocation, then by all means, they should be able to retain their money. But if it's this practice of the abuse, and I understand in Lynchburg and Amherst area, it's 15 times a week.
Why can't you just say you can't bond somebody out who hasn't asked you to? It seems a lot simpler way to do this. This seems a very convoluted way of solving this problem.
That's a good point.
Okay.
Proving that might be difficult because the person, by the time they get to the magistrate, most everything's done, they're booked out. It's hard to reverse that whole process. So I think the best way would just be to eliminate the practice by saying you have to surrender that 10% to the magistrate or clerk when you get the paper. And then once that paper's served, you have 15 days to petition the court. They have this similar thing in Maryland. They have about the same law that works really well.
It's your industry, so if
Yes.
you don't think that's going to negatively affect legitimate actors, then
We
I'm
discussed
less
it.
concerned about that.
We've discussed it, and we feel like, yes, it's going to cause us just a little bit of pain, but in the long run, it's going to relieve a lot more.
Okay. Any questions for either the patron or the lawyer? Okay. Anybody in the audience wishing to testify in favor of this bill, please come forward. Anybody in opposition? No, please come forward. Staff, do you have any comments or issues? Okay.
I do have a second bill. This one's a little easier. It's a HB 2464. This is the, this came from the Crime Commission. Two bills that I've carried, one in the civil side, one on the criminal side, is raising the age to 14 for individuals who are victims of crimes to be able to testify in camera rather than in person. By camera, excuse me. What did I say? In camera? Only one so by camera, under age 14, so they don't have to testify in public. And I think this is all cleaning up language that we've done before, or raised the age before, but we left out certain code sections. This catches all the other code sections back up. Now it should be uniform across the various volumes that's both civilly and criminally a victim, a juvenile victim under age 16, does not have to testify in public in civil or criminal hearings if they're under the age of 14. That was the purpose of all these bills. Wait, I'm sorry.
Okay.
Yes.
Any questions for the patron? Yeah, I have an issue.
Mr. Chairman, what this bill does is it actually doesn't, this was already 14, this statute. This adds a section of crimes for which the court could use this video testimony. This adds any commercial sex trafficking or prostitution offenses pursuant to Article 3. So any prostitution related offense from prostitution up to felony of commercial sex trafficking, the court, and it still has to follow the procedure that's laid out in the statute, just adds those crimes to those. Right now the crimes are abduction, criminal sexual assault, and family offenses.
Does everybody understand the bill now? Delegate Harris.
It's gonna, no, I understand, yeah, no, I
Crime
understand.
Commission, what is going on with the bill?
Yeah, I know. And just sort of refresh my memory then, on confrontation, yeah, just the constitutionality. I just need to be refreshed.
This procedure was found constitutional in Johnson v. Commonwealth in 2003, as long as the video is too wet.
Yeah, just having done this before, you'd have the prosecutor, the defense attorney, and the judge, and the victim separated from the main, but everyone can watch it in the courtroom on the TV. So that's the purpose of it.
All right, anybody wishing to testify in favor of or, thank you, in opposition to the bill? Okay, Delegate Bell.
Mr. Chair, I was going to ask you if you wanted to tell people that almost all of us are literally on the Crime Commission. We've had lengthy hearings on this, so if this feels as if it's already. All right, Mr. Chair, I would move to report the bill.
Motion to report. Second. Any further discussion? Hearing none. Please cast your vote. Okay. Bill is recommended to report. Okay. Which one? That bill is recommended to report. You want to come back? Which bill? Tell us the bill.
We'll start with HB 2648, which is Delegate Orrock's bill. And after speaking with the stakeholders in this, and looking more carefully at the language, the proper amendment would be line 75, strike by the Attorney for the Commonwealth, insert by the Commissioner of the Department of Behavioral Health Services or his designee, and do not touch little I two. Just change Attorney of the Commonwealth to Commissioner.
What about our notice, trying to track that to the other statute rather than having a separate freestanding, we'll mess it up down the road?
The other statute, notice provision, deals with notice of a hearing dealing with the release is one of them. And then, so it's not exactly the same as straight up release. And then the other 182.4B is notice of community visits to any victim. So I think it is there are three separate.
Mr. Chair, that's great. I move to amend the bill as described by staff.
Delegate Bell moves those amendments. Is there a second? All those in favor say aye.
Aye.
Those opposed, amendments are adopted.
And I move
Yeah, thanks. Appreciate it. I've learned that things.
We're gonna have a super quorum. Excuse me. The group separates and keeps it down. Yeah. Oh, we're gonna.
Oh, I'm sorry. Thanks, Jeff. Hey, thank you. Appreciate it. Okay. No, you are.
Burr. Okay. Is there a motion to report already? All right, everybody cast your vote. We adopted the amendment. All right, there is a motion to report. Please cast your vote. As amended. All right, close the roll.
Thank you, Mr. Chairman.
Thanks, sir.
Thank you for your hard work here. Thank you.
Mr. Chair, we received notice that House Bill 2548, Delegate Rush, is transferred to the committee on the list of police and public safety.
Probably be done.
No, they just amended it.
Okay. The chairman is pulling that bill back for the purpose of bringing to the committee. Yes. House Bill 2548 is going to be on the full committee agenda to refer to mission police. Delegate Bill, you have it.
I do, but I think they have language of Delegate Brewer and she could leave
Okay, Delegate.
2552.
Okay, go back to 2552. Staff, council.
Mr. Chairman, HB 2552, the changes to the bill will be to strike the language that has been included in the bill, starting at line 38 to line 52, which is subsection E has been added, and this is going to come out as a substitute. To add the language as follows. This is from 19256.2 with a slight change. Within 10 days after the use of the unmanned aircraft system has ended, comma, a copy of the executed search warrant shall be served on the person who was surveilled and the person whose property was surveilled. Service may be accomplished by delivering a copy to the person who or whose property was tracked or was surveilled, or by leaving a copy with the individual found at the person's usual place of abode, who is a member of the person's family, or other than temporary sojourner or guest who is 16 years or older, by mailing a copy of the person's last known address. Upon request and for good cause shown, the circuit court may grant one or more extensions for such service for a period not to exceed 30 days. Each good cause shall include, but not limited to, a continuing criminal investigation, potential for intimidation, the endangerment of an individual, or the preservation of evidence.
So you can put it on several times if you need to, as long as you have good cause.
That's correct. As long as, and you have to go back each 30 days to get it.
Yeah, but the other one was just 30 days period, right?
This is the exact language from the traffic statute.
No, I'm saying the existing bill was a 30 day, said 30 days, now it says
Yes.
10 days, but you can get 30 more and then 30 more for that.
That's correct, and this tracks the ceiling as well, with
Yeah.
a circuit court that can continue on in perpetuity.
Okay. All right.
Mr. Chair, move the amendment.
Okay, the amendments are before us. Is there a second action?
Second.
All right. All those in favor of adopting the amendment, say aye.
Aye.
Those opposed? Everybody here with that? I'll let everybody come along. Okay.
Mr. Chair, so just trying to visualize this in my head, this would be a new paragraph E like this one. Okay.
Go ahead.
This one begins, the law enforcement officer applies for a search warrant, so it's clear it's referring to those cases where the drone is
though, because the first portion is talking about the within 10 days, but then it says a copy of the executed search warrant. For that, you're talking about that, so I think that's
Okay, so I see a gentleman behind you who cares about some of our civil liberties, and he would like to come and talk about this bill. So yes, sir, please come forward.
Thank you. Good evening, I guess it's now evening. My name is Charlie Schmidt with the ACLU of Virginia. Paying deference to the patron and law enforcement, we do have some problems, I think, with the fact that pulling a procedure, I'm still a little unclear about the procedure. The procedure for GPS is laid out pretty clearly, and then by law, the sealing is granted, right? Sealing of warrant, and then we understand that, you know, if a defendant is, or a perpetrator is committing a crime, then we tell them, hey, you're going to be tracked, you're going to be followed, and that's understandable. The GPS section of criminal procedure specifically excludes any devices that record images, viewing images, monitoring, collecting, capturing images, oral or wire electronic communications. So there's that standard, that procedure, and that standard is automatic by law. So if an officer goes in and says, I want to track someone with GPS, there's a lower standard for the procedure, it's granted by law, then they can go in and show their cause. Because the GPS just tracks where people go. The drones, as we've said before, you know, the analogy is a helicopter, the analogy of plain eyes, or police officers trying to do something in real time, do surveillance, is completely different than the technology that now exists with drones. And you're basically saying that you're going to give, by default, by law, an officer goes into a magistrate and says, I want to, you know, do this. I want to basically spy on someone in their property or on their farm for 10 days and then come back for 30 days and continue this process. Well, anyway, I mean, I'm just a little concerned about the procedure and the sort of lower standard that's going to be applied for drones, because as we've said before, we have a real problem with the amount of information that drones can capture compared to GPS tracking, compared to my opinion.
Mr. Chairman, I think that the search warrant still has to specify when it can be used and for what length and what it can. This is just a service, how to serve the search warrant once it's been executed. So it can't. I don't think it's not that you can spy for 10 days or surveil for 10 days and then surveil for 30 days. It's you can hold off on serving the executed search warrant that specified the amount of time and where and when the search warrant could be executed that was issued by the magistrate.
Sorry. Again, Chairman, I understand that, and with other search warrants, that's understandable. I'm not saying this is somehow writing that constitutionality out of this particular search warrant. It's the idea that, you know, police officers go on someone's land and do a search. They show up, they say, you know, you stand back, we're going to search your home, we're going to do this, this is your property. And from my understanding, the reasoning is they don't have to do it in this instance with a drone. So, and I'm not, you know, with the balance of privacy rights, it's always a problem, but with the balance of police officers showing up with the drone in hand and having the search warrant and saying, we're here to surveil your property, we're here to basically execute a search warrant with the drone, here it is, we're going to fly over. I don't see why that's a huge burden compared to the privacy rights of you don't know when drones are flying over and what they're capturing, and being that they can capture so much more than GPS and other sort of surveillance tracking devices.
All right, thank you, Ms. Mayor.
Mr. Chair, members of the committee, Michelle Sutherland on behalf of the Unmanned Systems Association of Virginia. We represent the industry. We support this bill. We support the efficient and resourceful use of drones within the state government. We think they provide cost savings, and we support it. We hope that you'll pass this bill.
Thank you. Ms. Mayor.
Eileen Longanek from OES at the Supreme Court. Just to clarify, the magistrates are not authorizing the use of a drone. They're issuing a search warrant. Should law enforcement choose to execute it by using a drone, then they can do that. But the magistrate is not authorizing the use of a drone.
Okay.
That's my understanding.
Yes, sir. Couple of terms.
Yeah, on the, and we support this bill. But the law picked up on it.
Thank you. Anybody else in favor or opposition? So, there's still probable cause to believe somebody's committed crime, right? That is your point. sure of that?
Well, that depends on the amount. I mean, this, as far as I know, read this amendment, and this doesn't have anything to do with the issuance of the search warrant. It's just how it must be served on the person. When a search warrant is served on a person, it's executed, we had the discussion in the hall about whether or not, if the drone goes up and then the battery guy has to come down, is it going back up a separate search? You need a new search warrant. I just don't think that law there's no law on that issue at this point. So that's not, I think, what this is doing. It's just giving you a procedure by which to serve the search warrant.
Okay.
Move to report the substitute.
Motion to report the substitute. There's a second. Is there any further discussion? All right, hearing none, please cast your vote. Close the roll. No. Okay, go.
Delegate United, Delegate Lopez.
Delegate Lopez. Still on the second block.
Good afternoon, Mr. Chairman, members of the committee. Thank you for the time to discuss this important legislation. This legislation seeks to address a major public safety concern affecting my community and really the entire Commonwealth. Immigrants make up a substantial percentage of Virginia's population. Over 12% of Virginia's residents are estimated to be foreign-born. In my district, it's 38%. Over the last couple of years, a chilling effect has descended on police-community relations due to the perception within a large segment of the immigrant community that police may report their immigration status to the federal government. This chilling effect has had a dramatic impact on public safety in communities across Virginia. When the members of Virginia's large and growing immigrant community become the victims of a crime or witness a crime, many no longer choose to report those crimes or cooperate with prosecutors due to their fear that interacting with law enforcement may place them or their loved ones at risk of having their immigration status reported. In one neighborhood in my district in Arlington, reports of domestic violence dropped more than 75% in the first 8 months of 2017, and reports of sexual assault and sexual violence fell 85% in the first 8 months of 2017. As a result of this fear, all of our communities are less safe because crimes go unsolved and perpetrators go free. This legislation would establish a uniform statewide policy against routinely asking victims and cooperating witnesses of crime about their immigration status. It would also work to reestablish the trust between law enforcement officials and the immigrant community by repealing sections of the code that force state and local law enforcement to assume the responsibility of reporting immigration status to federal authorities. This legislation strikes a balance between giving police the latitude they need to effectively investigate violations of state and local law, and giving immigrants the reassurance they need to feel safe about contacting the authorities. It's not just undocumented immigrants, it's also legal immigrants who are actually scared to report. Many Virginia localities already have similar policies. However, the current patchwork of local policies is really inadequate and pretty ineffective in promoting confidence and cooperation. Several Virginia police departments, including Prince William County, City of Richmond, and City of Virginia Beach, have instituted prudent local policies to reassure victims that they will not have to be revealing their immigration status. In a nutshell, this bill does not interfere with lawful federal enforcement of immigration laws and affords no refuge for violent criminals. In fact, it helps ensure that no community is safe for criminals who may prey upon victims and witnesses because it encourages Virginia residents to work with the police. This would allow the police to operate more efficiently and effectively by providing them with more opportunity to work with crime victims and witnesses, but also by removing the possibility that undocumented immigrants could come to the attention of immigration authorities due to simple, non-violent infractions like parking tickets or traffic violations, which happens in Virginia and across the United States far too often. This bill will help bring perpetrators of domestic violence and sexual violence to justice and aids in anti-gang initiatives. It facilitates the investigation and prosecution of crime by enhancing cooperation with the police. Community-based policing has been time-tested for decades and working very well in Northern Virginia as a successful model of crime prevention and reduction. For its success to continue, it relies on a central relationship of trust and cooperation between the police and residents of the communities they serve. This is a public safety crisis that needs to be addressed so that bad actors are not able to take advantage of the fear that is rampant in Virginia's immigrant community, both documented and undocumented. This bill is also critically necessary to reestablish the trust that took generations to build between our law enforcement and immigrant communities. Doing so will protect some of our most vulnerable neighbors, as well as make all of us safer. I hope it's the will of the committee to pass the legislation.
Thank you, Elliot. Anybody in the audience wishing to testify in favor of this bill, please come forward.
My name is Jasmine Leeward. I'm here representing the Virginia majority. Our communities are safer when local police don't act as deportation agents. If our communities trust local law enforcement and don't have to worry about whether interacting with their police will lead to deportation, they're more likely to trust them and come forward when they are witness or victims of crimes. A University of Illinois study found that 45% of immigrants, including documented immigrants, were less likely to report a crime as the result of increased involvement of local police in immigration enforcement. Local police and sheriffs have plenty of responsibilities already without having to take on the duties of the federal government. So for these reasons, the Virginia majority urges the passage of this legislation. Thank you.
Hi.
Hi, good evening.
Welcome.
Thank you. My name is Margie Del Castillo. I'm here on behalf of the Virginia Coalition for Immigrant Rights. Just to say that we support Delegate Lopez's bill. We support any bill that encourages immigrants to come forward and to continue building their trusting relationship with the police and to be able to be reporting crimes and also be reporting when they are victims of crimes. Thank you.
Thank you.
Good afternoon, Monica De Martinez, representing Casa, Virginia. We support this bill. We want our communities to feel safe, to feel empowered, to cooperate in investigations, to build relationships, and we just don't want ICE in our communities.
Good evening, my name is Diego with Church World Service. We support this bill because of community-led efforts that have happened here in Richmond, where the Richmond City Jail has welcomed community-led initiatives to make it easier for community members to report crimes, as well as in Chesterfield County, not too far from here, where the Commonwealth Attorney has even said that he wants better community relations because people just aren't showing to courts and it becomes insufficient for them. So we hope that you support this.
Hello, my name is Seema Sked, private citizen. As a Muslim, I hope you support this bill.
Good afternoon. My name is Hassan Ahmed. I am an immigration attorney and I've practiced criminal law and criminal defense and immigration law for the last 15 years, 12 of which are in Virginia. A couple of years ago, I taught the first continuing legal education for the immigration consequences of criminal activity for Virginia criminal defense attorneys for VACLE. I am, in fact, a crimmigration lawyer, and that is a real field of law. Crimmigration. And I've actually practiced in it for the last 10 years. I can assure you.
Did you coin that phrase?
No, I did not coin it.
Okay.
No.
Collins is trying to trademark it right now.
Probably should. I'm using it in Congress for that purpose. So, this bill restores the law. It ensures that the punishment fit the crime, and that nobody is not going to be punished or is afraid of coming forward just because of their immigration status. I want to tell you all a little secret. I've been practicing immigration law for about 15 years. It takes me at least an hour of talking to a client and asking a ton of questions to determine what their immigration status actually is and what forms of relief they have. There's this presumption that immigration status is black and white. Either you're legal or you're not, or you have papers or you don't, and the system just isn't that simple. There are a lot of people, my clients that I've served proudly for the past 15 years, okay, who aren't sure what their status may be, and until they get the right advice at the right time, they're not going to be able to make it forward. Why are we trying to take this labyrinthine system of immigration law and put it onto our law enforcement officers, or our DMV clerks, or anybody else? It is complex. It is difficult to understand. We can't be in this position where we're trying to burden our law enforcement with making determinations on whether somebody may or may not have the right to remain in this country. We have a system, a very backlogged, overworked system to make those determinations. With experts, people that have understood the law and have revised lots of provisions of the law to make sure that these determinations are made while respecting due process. That can't happen at a traffic stop. That's not going to happen running a name through a database at a jail. I can give you example after example after example of, because of the lack of respect for due process, because of the way the system is set up, and not being able to have people tell their story and what their claims are for remaining in the United States, they wind up getting deported. That should shock the conscience of each and every single one. Like a client of mine in 2013, she was convicted of grand larceny, which at the time was due to a handbag. At the time, of course, the threshold was $200. She got picked up by ICE and sat in detention. She got a suspended sentence in 2013. They didn't actually send her to jail, but the suspended sentence was 365 days. All right, for the grand larceny. She got convicted, she got picked up by ICE, and spent the next 14 months in immigration custody while I filed a habeas and appealed it all the way up to the Supreme Court of Virginia, only to have her deported to the Philippines 3 days before Typhoon Haiyan hit. Right after she got to the Philippines, the Fourth Circuit decided Omar Garib versus Holder, and the crime that she was convicted of, the grand larceny crime that she was convicted of, no longer was an aggravated felony under the immigration law. When we try to put immigration law and criminal law together, one body of law says you're innocent till proven guilty. The other body of law says you're deported unless you can show a reason to stay. One side you have a jury, trial by jury, right to a speedy trial, right to counsel. On the other side, you have none of those things. What do you get when you have these two bodies of law meshed together as if they were supposed to, like oil and water? You get a giant mess. And I'm here to tell you all are in a unique position with this particular bill to start the process of restorative justice, to make sure that just because someone's status has not yet been decided.
I need you to wrap up, sir.
This is the last thing I'm going to say.
I know the lawyers get to this podium and it's like, come on.
I apologize.
Sorry, no, we
This is the last thing I'm going to
understand,
say.
believe me.
You're in this position to be able to make a decision, to make sure that that the punishment that someone will face, or the fear that they're going to have in reporting a crime, is not going to be dictated by the uncertainty surrounding their immigration status. I would ask you all to, if you stand for that principle, that the punishment should fit the crime, and that nobody should be punished in an administrative manner or meting out criminal-like punishments without the corresponding constitutional safeguards, you need to support this bill. Thank you.
Thank you very much. Yes, sir.
I'll be quick. Mr. Chairman, members of the committee, Ben Owen with the Virginia Interfaith Center, representing tens of thousands of people of faith from across the Commonwealth. We are in support of this bill. As people of faith, we practice love thy neighbor. Additionally, we believe it takes a village to raise a neighborhood and make a community safe. And as Delegate Lopez and some of the speakers spoke to, our communities are actually much safer with this legislation passed. So Virginia Interfaith Center and people of faith across the Commonwealth support this bill. Thank you.
Thank you very much. Anyone in opposition to the bill, please come forward. Just going to take everybody on by yourself. Oh, no. Okay, go ahead, Mr. Doucette.
Mr. Chairman, Mike Doucette, Executive Director of the Virginia Association of Public Attorneys. And our concern is with the deletions. The deletions on lines 94 through 98. The deletion of 19.2, the deletion of 19.2-294.2. We have obligations under international treaties under the Vienna Convention to ascertain the citizenship of people who are not citizens and notify their consulates. Just as we expect those Americans who are locked up or arrested in Europe, wherever, Asia, that our consulate is notified, we have an obligation to notify the embassy or consulate of these people's home nations. And this is basically going to prohibit us from meeting our international treaty obligations.
Thank you. Yes, sir.
Thank you, Mr. Chairman. Lieutenant Gilbert with the Virginia Sheriff's Association. I'm not an attorney. We oppose this bill for the reason you stated.
Okay, thank you, sir. Delegate Bell.
Mr. Chair, I'm going to ask staff a question. We've had a fair bit of discussion about what happens at the very beginning of the process when the person being arrested talks to the officer, but isn't 294.2 is deleted at the back end after someone's been convicted of a felony? This would preclude the probation officer protecting immigration status even of a convicted felon?
Yes, this bill repeals that statute which requires the probation officer to inquire on felony conviction of somebody's immigration status.
Mr. Chairman,
Delegate Bell makes a motion to PBI. Second for 2. You have 2 minutes.
The fact is that I disagree with the Vienna Convention argument. If it should be an option, an opt-in by the individual to do that. It does not need to be automatic. In fact, the legislation creating that was only created a few years ago. I think the council can attest to that. We were fine before that legislation was put into place. At the same time, the fact is that we have this problem. It exists across the Commonwealth. We have people who are living in fear, including folks who are here legally, but have undocumented friends or relatives who are scared even talking to the police. So what's happening is that our community policing efforts that we are very proud of in Northern Virginia and across the Commonwealth are slowly eroding. And what's happening then is that people who are bad actors know to prey on this community. We have it in our power to actually address this, to make it better. We should. And the fact that we're PBI in this bill, I think, says a great deal about where the Commonwealth is right now and where I hope it will change in the future. But let me also say that the fact is that people in my community are hurting. They're hurting. The fact that we have to pay more money for psychologists for kids in Arlington County schools and Fairfax County schools because they're concerned that their parents might not be there when they go home because of the ICE pickups that are happening randomly. We have the ability to affect change and to make things better. And this legislation does that. And quibbling because something has been this way for a few years is not a reason to kill the bill. So I hope you'll pass it, but I appreciate your time today.
Okay, thank you, sir. Motion is the PBI. Please cast your vote. Okay, close the roll. That bill is passed by indefinitely. Thank you, delegate.
Thank you.
Mr. Chair.
There you go. Delegate Bell.
So we have the non-marijuana bill. Here, we need to do the marijuana bill. Carter, Heretic, Herring, Corey, Cora. I'm not sure. Cora is on the back. Corey, Heretic, Carter, everyone else here. Bobby is a different thing. That's about doctors. Okay. Mr. Chair, I'd like to suggest we can take a little 5-minute.
All right, we're going to take a 5-minute break. Not much longer than that. And then we will on the reconvening of the subcommittee, take up Delegate Carter's bill and then proceed with all the bills related to marijuana, et cetera. So we're in recess for 5 minutes.
How you doing? Rough. Yeah. As usual. What are you gonna do?
You have to go get some snacks.
Every day around here.
There'd be more people here. Where is she? Oh, she's up there. Yeah. Yeah. I want to get a picture of her. Okay.
I've been working.
Yeah, I don't know.
I just wanted to. I just wanted to say hi around.
Yeah. I don't think Amanda's in here. Just say Amanda.
All right, so we have reconvened the subcommittee. What I intend to do is a little different than the way we normally do it, since some of these are so closely related in concept. I'd like to ask each of our three patrons on the legalization, decriminalization fronts, to just come present your respective concepts, and then let's take testimony from the audience, and then we'll try to work through the varying approaches. So, Delegate Carter, you've been waiting a long time. Thank you.
Thank you, Mr. Chairman, members of the committee. I am presenting House Bill 2373, which will fully legalize for recreational purposes cannabis and cannabis products in the Commonwealth of Virginia. This is a significant change from current law. It is a significant question that I'm asking you to take up, and correspondingly it will be a very significant presentation. First of all, there is a growing consensus among residents in Virginia and throughout this country that the most dangerous thing about cannabis is getting caught with it. Cannabis, particularly its active ingredient, tetrahydrocannabinol, has an extremely low risk of overdose. The ratio of benchmark dose, that is the normal dose that it would take to kill you, compared to the average dose for human consumption is well over 10,000 to 1. That ratio for legal substances like nicotine and alcohol is less than 10 to 1. There are significant medicinal benefits to liberalization of cannabis policy. The Journal of American Medicine Association's Internal Medicine saw that in states which legalized cannabis and cannabis products, they saw a 6.38% reduction in opioid prescriptions and a roughly 25% reduction in opioid overdoses. In many parts of the state, including in the city of Manassas, we have a significant problem of opioid overdoses and deaths. I know most people don't associate Northern Virginia with the opioid crisis. However, in the city of Manassas, our opioid death rate is roughly on par with that of Giles County. Our incarceration rate is the highest in the world in the United States. It's the highest of any nation that has ever existed, and cannabis prohibition contributes significantly to that. According to prisonpolicy.org, the United States national average incarceration rate is 698 for every 100,000 residents. Virginia's rate is significantly above the national average at 779. If Virginia was a nation in and of itself, it would be the 16th highest of any nation, including the other 49 states. Every new nation above us would be another state. The closest foreign country to our incarceration rate is El Salvador at 614. This has a tremendous impact on our budget. We currently spend roughly $1.3 billion per year on the Department of Corrections. And nationally, over $3.6 billion per year is spent enforcing the cannabis prohibition. There is a significant racial component to the cannabis prohibition. A 2017 National Institutes of Health study showed
that comparing cannabis usage rates by race, there is only a negligible difference between the usage rates of Black Americans and white Americans. However, Black Americans are arrested and incarcerated at nearly 4 times the rate of white Americans for cannabis-related crimes. And this prohibition, which has been in place for many decades, funds organized crime, just as the prohibition on alcohol between the passage of the 18th and passage of the 21st Amendments drove new sources of funding for the Prohibition-era gangs, such as those of Al Capone. The cannabis prohibition is a significant driver of funding for organized crime currently in the United States. In 2012, HSBC Bank was found guilty of laundering drug money for the Sinaloa cartel and the Norte del Valle cartel through Mexican subsidiaries and paid $1.9 billion in fines along with an admission of guilt. Illegal sales topped nearly $40 billion nationally per year. Imagine the kind of dent that we could make in our organized crime problems if they did not have that source of funding so readily available. Given the problems that I have laid out with our current prohibition on cannabis products, I propose the full legalization for recreational use for anyone over age 21. In this bill, you will find a regulatory scheme for retail production, sale, and use. It includes licensing and inventory control on growers. The licensing by the board would be broken down into 4 categories. A Class A license for producers of less than 100 plants at a time, a Class B license for less than 500 plants at a time, a Class C license for less than 2,000 plants at a time, and a micro-business license for less than 150 plants at a time to be sold on the premises, similar to a microbrewery or a winery's tasting room. There is also, contained in my bill, a seed-to-sale tracking system to ensure that cannabis products grown legally in the Commonwealth of Virginia do not contribute to the black markets in neighboring states. There are secure transport provisions, including the licensing of secure transport companies for transportation between cannabis cultivators and cannabis sale. The board would be tasked with promulgating regulations governing the security to make sure, again, that we are not contributing to black market cannabis sales in neighboring states. There is also safety and potency testing, similar to what the FDA requires for currently federally legal products for human consumption. The producer would have to submit a representative sample not exceeding 10% of their first harvest for safety and strength testing to assure that there are no harmful contaminants, such as chemicals that are toxic to human health, fungi or bacteria, and potency testing to make sure that customers know the strength and the dose of any THC products that they are purchasing. There are labeling requirements to include identification of the type of product, the serving size, and nutrition facts if it's an edible product, the potency and total dose of tetrahydrocannabinol, the facility of origin, and a health disclosure. There are dispensary licenses for facilities that would be authorized to sell not more than 2.5 ounces of raw cannabis product, not more than 1 pound of edible product, not more than 72 ounces of liquid cannabis product, not more than 6 flowering plants or 12 immature plants in any one sale. They would be required to sell face-to-face only with no automated sales, no vending machines, no online sales, no delivery, and no sale to intoxicated persons, quite similar to our current ABC laws. There would also be special event licenses for consumption on the premise of a special event such as a concert, and licenses for bars. These bars would be for cannabis only. They would not be authorized to sell both cannabis and alcohol products at the same location. There are limits on the licenses to guarantee that this new industry would have diverse ownership. No one owner would be able to have a major interest in more than 5 separate licenses. That's to guarantee that there is not an immediate monopoly on the sale of cannabis products when it is legalized. Turning to the end user, this changes the way we handle the use of cannabis by individuals. It would legalize it for anyone over the age of 21. You would be allowed simple possession of up to 2.5 ounces on your person and up to 10 ounces in your residence, with the amount in excess of 2.5 ounces to be stored in a locked container separately from the first 2.5. Consumption in plain view of the public outside of a home or a licensed cannabis establishment would be prohibited. DUI would still be prohibited. Blood tests are available for that, so it would be treated in much the same way as a DUI test for alcohol for someone who refuses a breathalyzer. There are provisions to allow home cultivation. Individuals would be allowed to cultivate up to 12 plants in their residence, provided that they do not have more than 10 ounces of raw cannabis in their home. And again, all amounts in excess of 2.5 ounces would be stored in locked containers. There are significant budgetary advantages to legalizing cannabis. As I mentioned earlier, we currently spend nearly $1.3 billion per year on the Department of Corrections. The fiscal impact statement on this was unfortunately a bit of a punt. The Department of Corrections said that they were not able to determine, so they just recommended a $50,000 positive impact on the Department of Corrections budget. However, according to that fiscal impact statement, there are approximately 13,000 to 15,000 possession cases per year that result either in incarceration or probation, all of which have a cost. We would be joining 10 other states, plus the District of Columbia, which have legalized cannabis products. Those states are Alaska, California, Colorado, Maine, Massachusetts, Michigan, Nevada, Oregon, Vermont, and Washington State, and as I said, the District of Columbia. Their sales vary fairly wildly. However, their average per capita sales come out to $95 per person per year. If Virginia were to track that average sale of $95 per resident per year, with the 10% tax that is included on retail sale, we would net nearly $81 million in new revenue each year, not including an optional 5% local tax. That $81 million would be distributed in several ways. The first $20 million of that revenue collected would establish the Veterans Treatment Fund, which would be used for grants for medical research, to be used to research medical cannabis applications for service-connected conditions, such as cancers from exposure to burn pits, PTSD, and veteran suicide prevention. Funding beyond the first $20 million would be distributed, with 35% going to education to fund standards of quality positions, 35% going to transportation, specifically the Highway Maintenance and Operating Fund, which would contribute significantly to our efforts to repair I-81 without tolls. And the remaining 30% would go. The remaining 30% would go back to the localities on a prorated basis based on their portion of sales. Additionally, any county or city would have the ability to impose a 5% local sales tax on cannabis products by referendum. Mr. Chairman, members of the committee, I know that this is a very new kind of bill that we have not discussed in this legislature previously. However, I hope I have made the case that there are significant benefits to be had from legalizing the sale of cannabis, so that we no longer have a situation where the most dangerous thing about this plant is having it.
All right, thank you, Delegate. Again, I think we're going to proceed and just hear the various concepts and then take testimony. Delegate Perrottin.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. Good afternoon. I know it's been a long day for all of us, so I'll try to be brief. I was a little confused why this particular bill went up in front of this committee to start with, because I merely intended this as an agricultural development and employment bill. Mr. Chairman,
last one's a transportation bill. So.
Mr. Chairman, I'm not going to recopy the comments just made by Delegate Carter. Our bills are similar in many, many respects. What I would focus on is this. I think it's time, and I think many of us agree, whether we want to admit it or not, that it's time to have a mature regulatory discussion about this. As we know, almost 40 states in the country, and by the way, the nation of Canada, have taken action to legalize or decriminalize marijuana. We would not be the first. I hope we will not be the last because, as Delegate Carter has alluded, and I think he's right, all this does is essentially what consuming and producing alcohol during the Prohibition did, and that's make criminals of individuals who choose to employ their personal liberty to make choices for themselves and choose in what they consume. I think it's time for mature conversation about these issues. My bill is somewhat parallel to Delegate Carter's in that the state would take a very proactive role in regulating everything from essentially seed to sale, that we would regulate under, at least in my plan, under the Department of Agriculture and Consumer Affairs, basically from everything from production to manufacture to packaging to distribution, and basically would prohibit sales to anyone under 21 years of age in much the same way we do alcohol, which would criminalize, in fact, the distribution to individuals under 21 years of age, but would take away the criminal onus that so many Virginians feel is unfair. I think you've read the bill. It is extensive in many respects, and I would leave it to questions. I do think that it is certainly worth a conversation, perhaps not here today, given the hour. But I think going forward, it's something that we, I think, as a legislature, need to look at closely. This is an issue about personal freedom. It's an issue about personal choice. And I will tell you, Mr. Chairman, I think you've heard me say this before, I'm a very unlikely proponent for this type of legislation, given my background, which is similar to yours as a prosecutor. But I think that we know now that the clinical literature, which basically objectively describes the physical effects of marijuana intoxication, show that it's certainly no more harmful than alcohol, and in many respects less. And in some respects, it even has medicinal purposes, as we know from Delegate Klein's bill, which was passed last year. I think it's time, Mr. Chairman, that we kind of look at this comprehensively, and we, as an assembly, take some action with respect to that. And if I can, Mr. Chairman, I would move along to my decriminalization bill briefly, since it seems to be the next thing on the docket.
Okay.
Mr.
Please,
Chair.
Delegate Bell.
There's two.
Yes, sir.
Just if you're doing it, but if you could tell us how different, what's different, what,
Different, I'm sorry, Delegate Bell, but we're different about.
the decriminalization, you have two bills.
Right, yes. Decriminalization is simply what it says. It basically removes the criminal conviction for adults over 21 years of age who are basically found to be possessing a half an ounce or less of marijuana, and creates a presumption for personal use. Basically, it removes criminalization. It sets up a civil penalty of, I believe, $50 for the first violation, $100 for the second, $250 for the third or subsequent violations, in much the same way we would pay for traffic tickets, essentially. It continues to make it illegal for juveniles to possess or use marijuana. And I would note for the committee that both of my constituent localities, the city of Norfolk and the city of Portsmouth, have passed resolutions calling upon this assembly to decriminalize marijuana. And I would note about 2 weeks ago, the Commonwealth Attorney for the city of Norfolk announced that his office will no longer prosecute simple possession cases. Now, this does not decriminalize sale, distribution, manufacture, those types of issues. That's a separate bill, and that's legalization, not decriminalization. But once again, I return to the point that as an attorney practicing in the courts, I had the occasion just last week to see a young man who was 21, 22 years of age, who was caught in a traffic stop. He was African American. For reasons I don't clearly understand, he was not charged with a traffic offense, but he had some marijuana in his hand. When the officer asked to see what it was, he was cooperative with the officer, he was respectful. He freely admitted what he had in court. And unfortunately, for that simple act, he is now precluded from holding any position in public safety, from having any position that includes a security clearance. I mean, his occupational opportunities now were foreclosed simply because he was exercising the choice to consume marijuana. Now, I'm not going to stand here and pretend that, we have any right or should have any right to smoke marijuana while driving, that we should certainly not have employment laws which would prevent an employer from restricting the use of marijuana by employees, because I no more want an airline pilot flying my plane under the influence than alcohol. But I respectfully suggest, Mr. Chairman and members of the committee, that we need to start looking at this like we look at alcohol. It is a personal choice. We have to regulate it, we have to manage it, we have to control it, but at the end of the day, as an adult, you or I should have this choice in much the same way we do with consumption of alcohol or tobacco. Not the best or healthiest things we could do to ourselves, but at the same time, as personal choices is something we need to consider. And with that, Mr. Chairman, I thank you.
All right, thank you, Delegate. Delegate Corey, do you also have a bill? Please tell us what your bill is.
Thank you, Mr. Chairman. I hope the members of the committee are sort of more awake than not at this hour, hearing so many bills. And I won't repeat what Delegate Carter or Delegate Heritage has said. I'm sure you know that my bill is congruent with many of the statements that they made. I will emphasize that it is time for us to examine this issue in a rational, logical way. Decriminalization of marijuana is coming, and we will honestly be left behind with serious problems if we don't deal with it and come up with an agreed upon bipartisan Virginia way of handling marijuana decriminalization for our communities. So again, my bill decriminalizes simple marijuana possession, provides civil penalties. It still prohibits anyone from driving under the influence or with possession at the time. And it also changes the civil fees, pretty much the same as the other bills that have been presented. I could give you an outline of the differences between the bills, but I won't. You're lucky. There are different ways in the bills we're all presenting of handling marijuana offenses civilly in court. Those are some of the differences. And I have talked to the other delegates about this issue as well as the governor, and we do have differences of opinion, but it's mostly about where the fine should be paid, to what fund the fine should be paid to. You probably noticed that in my bill and several others, it says the fine should be paid to the literary fund, whereas the governor's bill has it going to the drug abuse prevention fund. And I'm sure that those sorts of differences are ones that are really not germane to the main decision that we're having to make here tonight. Thank you.
Thank you very much. Delegate Herron, do you have
Just sort of summarize it. So I am carrying the governor's bill, HB 2370. Oh, I'm sorry. I'm carrying the governor's bill, HB 2370, which decriminalizes marijuana and creates a $250 civil penalty for simple possession. Different than current law, the penalties in this bill are not enhanced for second or subsequent offenses, which streamlines the process and prevents agencies and the courts from having to track offenses and hold hearings, and alleviates the disproportionate impact on communities of color and young people. It also eliminates the driver's suspension for adults and makes the suspension for juveniles, which then will also help us with the undue impact on low-income individuals. The bill also establishes a new crime for public consumption of marijuana and consumption of marijuana